Alright, we're back with the next part of the state's response opposing a motion for post-conviction relief to Steven Avery. This is the state's response to Kathleen Zellner's newest motion on behalf of Steven Avery in order to attempt to get him an evidentiary hearing. Alright, we're picking up where we left off. Avery's Brady claim regarding Kevin Ramlow was previously litigated but also fails on the merits. Avery's attempt to re-litigate his Brady claims that Kevin allegedly told law enforcement that he saw Teresa Halbach's RAV4 off the Avery property on November 3rd, 2005. By his own admission, he already made this argument to the court in his motion for reconsideration in October of 2017 on the grounds that Kevin's information was newly discovered evidence of a Brady violation, and he again relied on it as part of his July 8, 2018 supplement motion alleging that the contents of the Dassey computer would have allowed him to establish Bobby as a Denny suspect. This court denied the new claims Avery raised in his motion for reconsideration on grounds that new claims were not an appropriate reason to reconsider an earlier decision. A matter once litigated may not be re-litigated in a post-conviction proceeding, no matter how artfully the defendant may rephrase. Avery already litigated this claim. He claimed Kevin's information was newly discovered evidence warranting a reconsider of this court's October 2017 decision. The fact that this court did not individually address it when denying his motion for reconsideration is immaterial. It was presented to the court previously under one particular legal theory that this court properly denied it, meaning Avery cannot relitigate it, just as an appellate court is not a performing bear required to dance to each and every tune played on an appeal. Neither is a circuit court required to individually address in detail claims that are improperly before if it explains why they were improperly raised, which this court did in its prior decision. This court's failure to address it on the merits previously does not permit Avery to continuously raise it until this court does so. The record conclusively demonstrates that Avery could not establish a Brady violation at a hearing. Even if this claim were not previously litigated, it would fail because the record conclusively demonstrates that what Kevin says in his affidavit about telling Sergeant Andrew Colburn on November 4th that he saw the victim's RAV4 on a highway cannot possibly be true. Sergeant Colburn ended his shift on November 3rd, 2005 around 11 p.m. The affidavit Kevin submitted states that midday on November 4th in the Senex station, a Manitowoc County Sheriff's Department officer came into the station who he claims he told about seeing the victim's car. It wasn't until December 2016 that he recognized the officer who he talked to at the Senex station and that it was Andrew Colburn. But Andrew Colburn was off work on November 4th, meaning he would not have been in uniform or driving a squad car on that day. Even assuming, and it's a big assumption, that Andrew actually went into the Senex station on November 4th. Kevin, by his own admission, does not know Andrew personally. Kevin had no idea who Andrew was until he saw him on TV in 2016, and consequently, nothing Kevin states in his affidavit or that is claimed in Avery's motion can possibly have happened. Andrew would not have been identified as a Manitowoc County Sheriff's officer while he was off duty and thus out of uniform in a gas station, so there is no way Kevin saw him come in to the gas station, identified him as a sheriff's officer, and told him this. The record thus conclusively demonstrates that the state did not suppress any information about Kevin's tale because there was nothing to suppress. The evidence does not exist. Finally, Avery has once again failed to plead sufficient facts that this information from Kevin could have been material. As explained above, Avery did not plead sufficient facts to satisfy the three prongs of Denny and allege that Bobby was a plausible perpetrator, so the jury would not have heard that theory, which is the only way there would have been any exculpatory Context to this information. Assuming that Kevin's information standing alone would have been admissible, there is no reasonable probability of a different result at trial. Kevin seeing a car similar to the victim's on the side of the road between November 3rd and November 5th does nothing whatsoever to exonerate Steven Avery. Avery himself could have easily driven it there. After all, the state had no way of knowing what Avery did with the evidence between October 31st and November 5th. At best, Kevin's evidence would have allowed the state to fill in its own gaps in how Avery kept the victim's car hidden between her disappearance and the car's discovery on November 5th. There is not a reasonable probability that the jury would have reached a different outcome if presented with Kevin's testimony. Circuit courts have no authority to grant a new trial in the interest of justice when the request is made. Avery's final request is that this court grant him a new trial in the interest of justice. There is no need to belabor why Avery fails to meet the requirements for such relief, because the Wisconsin Supreme Court has unequivocally held that the circuit courts have no authority to grant new trials in the interest of justice in criminal cases, nor can such claims be raised in a motion because they are neither jurisdictional nor constitutional. Interest of justice claims can only be considered by the circuit court if they are presented in a defendant's motion on direct appeal. As this is not such a motion, the court lacks the authority to grant Avery any relief on this claim. Conclusion: Avery has not pled sufficient facts to meet the three prongs of Denny, and the record conclusively disproves much of what he states, which means his Brady violation and newly discovered evidence claims could not prevail even if he established the facts he alleged at a hearing. Even if he had met his pleading burden through what he submitted, did not establish he could meet the newly discovered evidence or Brady test, because he cannot show that there is reasonable probability of different result at trial if the jury were presented with Thomas Sawinski's or Kevin's evidence. This court should deny Avery's motion without an evidentiary hearing. Dated November 23rd, 2022. Respectfully submitted, the Attorney General of Wisconsin. Woo! Alright, well, that is the state's motion to opposing a post-conviction relief hearing on behalf of Steven Avery. They do not want an evidentiary hearing. They do not want a hearing of anything. It'll be very interesting to see if Kathleen Zellner responds to this. I hope she does. I'm looking very much to her poking holes in everything the state has said, because she is very good at doing so. Let me know what you think. Thank you for watching this past multi-part video once again. Let me know what you think. Leave some comments below. I hope you're having a good day, and I'll see you again soon.